Hello, aspiring civil servants. The controversial Armed Forces Special Powers Act is back in the news. And this time, for a change, for a good reason. The Chief Minister of Assam has announced that the act will be revoked from the state very soon. In this context, I, Jawwad Kazi, will be discussing this issue threadbare while tracing its historical footprint. In case you're wondering where you can get updates about my videos, you can follow me on Telegram, Jawwad Kazi UPSC Preparation, that's my Telegram channel, or you can click on the link to get access to my Telegram channel, or you may also scan the QR code to directly join it. Without further ado, let's dive in and see what the issue is. Hemanta Biswa Sarma, the Chief Minister of Assam, has recently announced that AFSPA will be lifted from the state by the year end, by November, as early as November. After the act is revoked, the CAPF battalions will be replaced by Assam police battalions. CAPF presence will be maintained as per the law, but the role primarily will be discharged by the Assam police battalions. Assam was declared a disturbed area under the act way back in 1990, and ever since, the disturbed area tag has been renewed as per the law every 6 months. Currently, 8 districts of Assam are tagged as disturbed areas. Earlier, it used to be a much bigger area, but over the years, as the law and order situation has improved, lesser and lesser districts have been considered as disturbed areas. Assam is planning to rope in ex-military personnel to train their armed police so that the law and order situation could be maintained as it is right now. Now, in this context, guys, let us try to understand this particular issue in depth. Now, in the first place, what is meant by this Act AFSPA? Armed Forces Special Powers Act was passed by the Parliament very early into the nascent stage of our independent existence. 1958, this particular act was passed primarily to counter the Naga insurgency that we were seeing in some parts of our northeast. Originally, the act was limited to Assam and Manipur. Now, please remember, Assam back then was a massive state and it included all the northeastern states except Manipur, and over the years, others have, developed or matured out of it. So Assam back then was a much bigger entity. Why did we have to pass this law in the first place? Now, while dealing with insurgency or such other situations, the armed forces need some elbow space to be able to discharge their duties effectively. And for that purpose, certain powers or immunities were given to the armed forces personnel so that they could focus on discharging their duty rather than worrying about what will be the implications of their actions. In this context, certain immunities were given to the armed forces personnel so that they could bring peace to these disturbed areas. That is the whole aim of AFSPA. Currently, Nagaland and Arunachal Pradesh in northeast parts of these states, they have some disturbed areas where Home Ministry periodically comes out with notification of disturbed areas. But in case of the states of Assam and Manipur, where the act is still applicable, there it is the state government which issues notification regarding further continuation of the disturbed area application of AFSPA as such. Now, what is the historical background of this act? How did it come about, and what have been the changes that have gone by in this process? The act actually owes its origin to pre-independence period. During Quit India movement, the Britishers wanted to deal with the mass upsurge of the people and therefore arrogated some special powers to the law and order machinery. And for that purpose, Armed Forces Special Powers Ordinance was brought about in the early 1940s itself. After independence, Assam Disturbed Areas Act was passed 1955 to deal with the fissiparous or separatist kind of tendencies that were there in some parts. Later in 1958, the AFSPA Act was enacted, as we have noted earlier, to suppress these secessionist movements. 1972, this act was amended, and along with center, the state was also given concurrent power to declare an area as a disturbed area. So originally the act is brought about for dealing with or tackling the problems in Northeast, and later on other areas were also brought under this act depending on the need. For example, Punjab and Chandigarh in the 1980s saw the application of AFSPA in the wake of the Khalistan militancy that was active. Kashmir, which started to boil in the late 80s, also saw the application of AFSPA from 1990 onwards, and ever since in parts of Kashmir, it is applicable. In Northeast currently, Assam, Nagaland, Manipur and Arunachal, these are the only states where currently AFSPA in some parts is applicable. So this is in short or in brief the historical background of this act. Now after this, let us try to understand how the act actually operates. Center or governor, they can impose AFSPA on the entire state or a part of it depending on the situation. The disturbed area can be declared. For this purpose, there is a special section in the act called as Section 3. Section 3 is used to invoke the concept of disturbed area under AFSPA. After an area is declared as a disturbed area, center gets power, constitutionally speaking, to send in forces to deal with the challenge or problem to law and order machinery in that state. You all know that maintaining law and order primarily is the responsibility of the state, but such contingent measures have to be taken for emergency situations. Once an area is declared a disturbed area, then after that, this status has to be maintained for 3 months at least. State governments in the meantime can recommend revoking of this application, but it is not mandatory or binding on the center to accept this recommendation as such. So this is sort of an extraordinary measure which the center has with it, considering the larger goals of unity and integrity of the country. So this is how AFSPA is basically applied. Now let us see, why is this act always in news? What are the special powers that armed forces have in the context of this act? What are their powers? Now, naturally, there are some extraordinary powers over here. Armed forces can search a premises or arrest a person without a warrant. So, unlike what you study in your fundamental rights section, here special powers are there for search as well as arrest without any warrant with the forces. But this is done under reasonable suspicion only. If there is a suspicion that a person is involved in some secessionist activity challenging the state, in that case, this power can be invoked for arrest or search without warrant. Next, opening fire. The armed forces can open fire on a mob or a group or a person, even causing death in that process if that person is in contravention of law or if he is carrying weapons. Now, typically what happens is, if there is any such incidents, then after that there is a long inquiry that goes on, and armed forces might feel intimidated because of the administrative judicial process after the event. And therefore, to give them sufficient insulation, they are allowed in disturbed areas to open fire even if it may cause death in the process, provided they feel that the person is in contravention of law or he is carrying weapons in that case. Thirdly, they have immunity from arrest and prosecution in context of the actions that they have performed for discharging their duty. So this special immunity is provided to the forces so that they can deal with the situation, tackle the situation effectively. Okay, so these are the wide powers that have been given to the armed forces. But while these powers are given, there are certain limitations also that have to be kept in mind. Limitation number 1, while discharging these duties, the armed forces have to keep the local police force in the loop. It is not as if they can act unilaterally. They have to keep cooperation and coordination with the district administration also. Second. Thirdly, if a person is arrested, then we have noted over here there can be arrest without warrant. In that case, the person has to be handed over within 24 hours of such arrest. And also, when they shoot, there has to be a proper warning given to the person or group who is being shot at, so that they can surrender if they are having any weapons, or some kind of measures can be taken there. So these are the limitations while exercising the wide powers that are given under AFSPA. So this is the next aspect of the AFSPA issue, the powers that are given. Now let us try to examine what is the constitutional status of the act and what is the opinion of judiciary on this very hotly debated topic. In the Naga People's Movement for Human Rights case, Supreme Court of India has given a landmark judgment on the AFSPA issue. Supreme Court has upheld the validity of AFSPA in principle. Means there is nothing in principle that is unconstitutional about the act. The idea of giving wide powers to the armed forces for a larger goal is well within the right of the state. So that is not an issue. But having said that, Supreme Court has said that it is desirable that the state government should be consulted before any declaration of disturbed area. The state government, which is the elected representatives of the local people, has to be consulted before declaring an area as a disturbed area, although it is not mandatory as such to follow the recommendation given by the state. Next, the Supreme Court stated that the application of AFSPA should be for a limited duration only. It should not be perpetual. And next, there has to be periodic review after every 6 months. Every 6 months, there has to be a review regarding whether AFSPA needs to be continued over there or disturbed area tag needs to be continued over there. Apart from this case, please remember this case law. I will recommend that you make a separate note, a list of important case laws. They come in very handy when you write answers in GS paper 2 particularly. Supreme Court in a separate case has upheld the procedural do's and don'ts which have been accepted by the army in case of AFSPA areas. So the safeguards that the army has put in to ensure that these measures are used effectively without violating human rights of people, that has also been accepted by the Supreme Court of India. This is a point from a separate case. Up to this point, we were talking about the Naga People's Movement of Human Rights case. So long story short, AFSPA is constitutional, but yes, certain caveats have been given by the Supreme Court. Now, after having seen the view of Supreme Court, now let us try to understand what do some important committees on this subject suggest. The first committee that we must know about is the Justice B.P. Jeevan Reddy Committee. Justice B.P. Jeevan Reddy Committee, headed by former Judge of Supreme Court of India, Justice Reddy, was given the mandate of reviewing the provisions of AFSPA and suggesting whether this needs to be amended, that is, the law needs to be amended, or it needs to be completely replaced with a more humane kind of an act. So the mandate of the committee was very clear. It has to examine whether the act needs to be repealed or it needs to be amended. And in that context, the committee gave its report in 2005 and it clearly recommended a repeal of the act. Justice Reddy Committee recommended repeal of the act, and instead it wanted some appropriate provisions be added to UAPA, Unlawful Activities Prevention Act of 1960s, 1967, late 60s. This is the premier act or most important act for dealing with terrorist and other such anti-national activities. So Justice Reddy Committee says that we can amend UAPA and have sufficient provisions over there and let go of AFSPA. This is the first committee that we should know about. After this, the issue was also taken up by ARC, Administrative Reforms Commission, ARC2. ARC2 also recommended the repeal of this law. And it went on to observe that if this law is removed, if it is scrapped, then it will remove the feeling of discrimination and alienation. In certain sections, there might be a feeling of alienation because of the separate treatment given to the people over there because of the disturbed area, and that alienation can be dealt with or it can be eradicated by repealing the law is what it says. Apart from this, we must also know about Justice Santosh Hegde Commission. This commission was formed in 2013 on the orders of the courts to investigate certain sample cases from AFSPA areas in the Northeast. 6 cases were given to Justice Hegde Commission to study their veracity, and in all the cases, the commission found irregularities or flagged some problems in every case. Supreme Court, while listening to Extrajudicial Execution Victims Family Association versus Union of India case in 2016, has also ordered the reinvestigation of many such cases in the Northeast. So we can see consistently the judiciary has been critical about the way the act has been applied, and several committees and commissions also have pointed out to many issues. Now, in this context, it leads us to a debate whether in the first place we should have something like an AFSPA or not. So what are the points in favor of AFSPA and what are the points against of it? As an aspirant for this exam, we must be able to understand both sides of the picture, understand the for and against of the story. So let us see the points on both the sides. Why should we have AFSPA in the first place? What are the arguments on that side? First and foremost, unity and integrity of the country. AFSPA as a law will be applied only in those cases where there is a serious challenge to unity and integrity of the nation. And therefore, desperate times require desperate measures, and AFSPA-like special act is justified for extreme circumstances is the argument given by some. Second, it helps to re-establish peace and order in that area. The people who are living there, majority of the people are going to be suffering because of a handful black sheeps. Now, to ensure that these people again live in peace and harmony, we have to take certain stringent measures. So, peace and order is an important goal for invoking AFSPA. Third, repealing of this kind of a law can affect the morale of the forces. Operating in disturbed areas is very risky. It takes a lot of toll on your mind, on your body. And in this situation, if the armed forces also have to bother or worry about post-event inquiries and proceedings, then their morale is naturally going to sag. So to prevent that sagging morale, AFSPA-like law which insulates them is critical. Then declaring areas inoperative of AFSPA can result in areas becoming safe havens for militants again. AFSPA allows search, seizure, arrest without warrant, and this helps to maintain peace. It helps to clamp down on anti-national activities. If some areas have become peaceful because of AFSPA, and there if it is made inoperative, then it might go back to square one, and that is the argument over here. Then the security of men and establishment on the field. Security forces are not only hunting down these people, but they are also constantly under attacks. So maintaining their security is also a very crucial aspect. And for that purpose, a stringent law like AFSPA is required. These are the arguments that we can cite on the other side. Now let us see the opposite side, points against AFSPA. What are the points of criticism against AFSPA? There have been allegations of extrajudicial killings, violation of human rights, even sexual misconduct. I'm sure you might have read about the long protest of Iram Sharmila in Northeast. That is again connected with these things. Democratic ethos and constitution. Now, the way AFSPA is invoked, there is a shift or tilt in favor of the center. So therefore, we can say that here it goes against the democratic ethos because the elected state government, the people over there are not the ones who are taking the final call. It is being taken by the center. So this can be one argument or what is often cited. Then it also suspends fundamental rights of our own citizens. We are guaranteed certain fundamental rights in Part 3 of our Constitution. But if an area is declared as a disturbed area, then because of the wide powers that the armed forces have, in a way those fundamental rights are compromised. Next, bypassing of the states. This goes against the spirit of federalism. Governor can declare an area to be a disturbed area and central forces can then move in. States can be bypassed in this process. So this creates a challenge before spirit of federalism. Often we see that even after AFSPA is invoked, normalcy is not brought in such areas. For a very long time, disturbances continue. So this argument in a way raises a question mark on the efficacy of this law in the first place. Next, once it is invoked, then it takes a very, very long time to revoke it. There are multiple reasons. There are complicated procedures because of which once an area is declared as disturbed area, then it becomes very difficult to revoke it. Now, recent trend suggests otherwise. In Northeast, we are seeing Assam is already going to or planning to get it revoked. Many areas which were hitherto considered disturbed, they have become free of AFSPA. So that is something positive. But nevertheless, there is an argument that it takes a very long time to revoke it. Next, it breeds a culture, real or perceived, about victimization or alienation. Citizens of the country, they might feel that they are being treated differently vis-a-vis people living in other parts of the country. And this may breed a feeling of victimization or alienation. So these are the challenges or the other side of the debate regarding AFSPA. So how do we conclude in such cases? The best way to conclude in such cases is go by what Supreme Court has said, uphold the validity of the AFSPA, but at the same time, you can comment that AFSPA should be invoked only in very extreme circumstances. Even when it is invoked, the standard operating procedures have to be followed stringently, and effort must be to get revocation of disturbed area tag as early as possible so that citizens of that area can live a fulfilling life. On that note, guys, I conclude this session over here. Thank you very much.